Good afternoon, everyone, and welcome you all to the roundtable discussion on IBBI Discussion Paper dated 6th August 2025 on measures to enhance integrity of CIRP. IBBI Discussion Paper dated 12th August 2025 on review of limited number of assignments being handled by IPs and on deletion of Clause 6 from Code of Conduct for IPs. Today we have with us Sucheta Gupta ma'am as moderator. Let me briefly introduce her. Ma'am is CS, IT and lawyer. She is associate partner of AAA Insolvency Professionals LLP, IP registered with IBBI. She is associated as consultant with Advocate Legal Services Law Firm since 2016 till date and in another firm of IT. She is also having one CS peer reviewed firm named Sucheta Gupta and Associates. He has also worked in the areas of IBC, SFAC Act, trademark, company law, secretarial audit, listing compliances, legal drafting, FEMA, taxation, finance, and accounts. Now I request ma'am to start with her.
Thank you. Thank you to the ICSI IPA and for providing again this opportunity to act as a moderator here. So I welcome to all the participants because the participants, I think they have earlier also attend some of our sessions, which was in which I was act as a moderator. So, the back-to-back since if we will say 6th August, from 6th August, the IBBI is issuing the discussion papers, amendment bill. So many changes have came. So, in this webinar, basically in this roundtable discussion, I will not only speak, I will take your all views, your all suggestions are invited here. So you all are invited to speak and suggest whatever in your mind for the further amendment. So the ICSI IPA can also make our proposals or our suggestions to the IBBI. So let's start without any delay. I just shared one of my PPT because I have prepared a PPT on one discussion paper, but other discussion paper I will discuss by showing the discussion paper. So I'm just sharing the PPT screen first. So is my screen is visible?
Yes, ma'am.
Okay, thank you so much. So we'll start with this discussion paper, which came on 6th August 2025, because this is a very important discussion paper. So what is the proposal basically made? So there are three proposals. My screen is visible now?
Yes.
Okay, thank you. So the proposal number 1 is there in this discussion paper, which came on 6th August 2025. So what is the proposal number 1 is here: recording of COC deliberation on RA's eligibility under section 29A. This is the first proposal. Now, because we as a RP, we are responsible, RA is responsible, but COC was never responsible for anything. So now it is proposed key recording of COC deliberation. This is very important. Recording of COC deliberation on RA eligibility under section 29A. Here, the ROC will also record its deliberation. The second proposal is enhance the disclosure in dissolution plan regarding section 32A. So some more disclosure have required to be made as per section 32A. Now, the third proposal is invitation and submission of resolution plan through the electronic platform, because we know we always submitted some of the liquidation if the company will go in the liquidation and after come into the into the force of electronic platform for the auction of the assets. So we will publish the liquidation sale assets on the e-portal. So same have required to be introduced for the for submission of the resolution plan through the electronic platform. So these three proposal was made by the IBBI. Now, as we know, because I will talk first proposal number 1. So we will discuss first what is the proposal number 1 and why the IBBI have introduced some of the more deliberation for the COC. So we will first discuss what was in the proposal number 1. As we know, regulation 36A is already in the as per the CIRP regulation. So what is provided as per 36A regulation? It provides that the invitation for expression of interest, because we all know that Form G have to be published and we invited for the expression of interest for the to the RA. So must state, because these are already the existing provision which already have. As per regulation 36A, as an invitation of expression of interest from G must state the ineligibility norms under section 29A, because this is already in existence. If there is any ineligibility of anyone who is submitting the plan as per section 29A, to the extent applicable for the prospective resolution applicant, sub-regulation 4, it shall provide that the expression of interest shall be unconditional and be accompanied by an undertaking, because it is already provided as per this regulation. And it is already saying in this regulation that the unconditional expression of interest should be there and accompanied by an undertaking by the prospective PRA, prospective resolution applicant, and it does not suffer from any ineligibility under section 29A to the extent applicable. So we have already this provision, we have already this regulation. Further, the regulation 38 of the CIRP regulation, this is also already having in the regulation, which require the resolution professional to conduct a due diligence to satisfy that the prospective resolution applicant complies with all the applicable provision of section 29A. So here is the responsibility is delegated to the RP. They have conducted due diligence to satisfy that the PRA complies with the applicable provision of section 29A or not. Now, section 30. Read with regulation 39, because 36A is already in existence, 38A is already in existence. Now, section 30, read with regulation 39, also require a resolution applicant to submit an affidavit along with the resolution plan stating that he is eligible under section 29A. So now this is the responsibility of RA, resolution applicant also liable to submit an affidavit along with the resolution plan state that he is eligible under section 29A. So RP is covered here, RA is covered here, PRA is covered here. So all are covered. But and further one more liability or also on the part of the RP is also mentioned here. Further, in the compliance certificate, because we know in Form H have required to submit the compliance certificate by the RP at the time of submission of the resolution plan. So the RP has to confirm that the affidavit provided by the resolution applicant is in order. Moreover, the RP has to attach the due diligence certificate under section 29A of IBC regarding the resolution applicant while submitting a Form H. So this is also the liability of the RP. They have confirmed that the affidavit, whatever is provided by the RA, is in order, and RP has to attach a due diligence. This due diligence certificate is required to be attached under section 29A of IBC regarding the resolution applicant while submitting in Form H. So all are liable here. PRA, RA, RP, everyone is liable here, but COC is nowhere is liable. But why these proposals came? So there are various provisions, because we know there are various provisions regarding section 29A compliance on the part of the RP, RA. There is a currently no specific provision under CIRP regulation for the COC to formally record its deliberation on the resolution applicant's eligibility under section 29A. So basically, there is no regulation which is imposed on the COC कि they will record their deliberation. So this is the compulsory कि have to introduce something for the COC also. So this is in our favor. Basically, after we say कि after a long time, something will come in the favor of the RP. So although it is implied that the COC, while exercising its commercial wisdom, will also ensure eligibility and express duty cast on the COC to deliberate on this aspect will enhance the transparency. Why this proposal is required? Ki by this way will enhance the transparency, accountability, ultimately the integrity of the CIRP. So this was the proposal, and why this is required. So I have also told you that there is no specific provision for the COC earlier. So this is required to be record the deliberation of COC also at the time of recording the eligibility of the resolution applicants. Now, what purpose will be fulfilled if this provision will come into force? Then what purpose will be fulfilled through this proposal? If we will see, firstly, it will encourage COC members to engage more deeply in the due diligence process. Basically, so include the seeking additional information or clarification from the RP or the RA where necessary. And secondly, such a framework would reduce the potential litigation on the eligibility related, because so many petitions have been filed before the NCLT that the RA is not eligible, but he has submitted the resolution plan. So by this way, the secondly, which have covered in the discussion paper, such a framework would reduce the potential litigation on eligibility related issue under section 29A. Moreover, an explicit record of the COC deliberation would enhance the transparency. Lastly, the deliberation with the COC would further uphold the legislative intent of the CEO code by promoting fair and lawful participation in the resolution process consistent with the spirit of the law under section 29A. So basically, this was the purpose of the IBBI. So they want that this proposal will came and the regulation will be accordingly incorporated. So what is the regulation they have proposed basically? So what is the proposed solution for this? It is proposed to further amend the CIRP regulation to explicitly amend the COC to deliberate on the eligibility of the RA under section 29A of the code, the due diligence report of the RP, the affidavit of the RA, and such other information as provided in the resolution plan. The RP will record the details of the deliberation in the minutes of the meeting also. So this have required the proposed solution is there, the have to record this deliberation in the minutes of the meeting also. So this part is also important. So what is exactly they have drafted as a regulation? I will read this regulation, the new regulation, the proposed draft regulation. So what is the proposed draft regulation is here? In the principal regulation, in regulation 39, after sub-regulation 3B, if you want to see this regulation, I will also show you. Just have to come on the screen.
Ma'am, can we increase the size of the slide?
Yes, I'm trying to adjust this. Yes.
Ma'am,
So,
I think it is on your right. This is the plus sign.
plus
So
sign.
you can increase the size
Oh.
of the
Actually,
slide.
I'm also opening up one more site. So can you see the site, whatever I have opened? This is okay now?
No, this is okay.
Okay. Okay. So this is the draft proposal basically. Now I am sharing one more thing here. My screen is shared now. So I just share this regulation with you. So this is the basically 39. I just want to go on the section regulation 39. So approval of resolution plan, because they have inserted this 3C basically after 3B. So I just want to show you that this is related to approval of resolution plan, and 3B is there. 3B is there. And after this 3B, they have inserted 3C. So what is the 3C? My PPT is showing now.
Yes, ma'am. So
Yes. So this is basically written in this 3C. The committee shall, before voting on a resolution plan under sub-regulation 3 above, deliberate on the eligibility of the resolution applicant under section 29A, due diligence report submitted by the resolution professional, the affidavit of the resolution applicant, and such other information as provided in the resolution plan, and the resolution professional shall record the committee's deliberation in the minutes of the meeting. So basically, it was inserted if the proposal will be approved. So this is the draft proposal for this sub-regulation. So they want to insert a regulation 39.3b after 39.3b as a 3c. The committee will deliberate its proposal on the eligibility of the RA, and this required to be recorded in the minutes of the meeting. So this is okay. We all are happy with this. I think so with this proposal. But one more suggestion. Some voice is coming from. So mute your mic. Now suggestion. What is my suggestion is here. He prescribed a standard format for recording the delegation. This is only my suggestion. They should also prescribe a format for the recording of these deliberations and ensure that all mandatory discussion points are captured to avoid the later disputes. So there should be a specific format for recording this deliberation. And the second suggestion from my side, the minutes should not only capture the deliberations, but also record the dissenting views, because some of the COC are not agree on the RA. So there should be a recording of the dissenting views or concern raised by the COC member for the transparency. So this is my suggestions only. Now I invite to all the participants, they can share what they want is further required to be amended in this sub-regulation or something. They can share their thoughts, or if they have no suggestion, then I will proceed further.
This is Shantanu Ray.
Yes, sir.
I'm
Yes, sir.
Shantanu Ray.
Yes,
okay.
Sir. Yes, sir.
So now, reading this,
Yes.
it seems to be simply a cursory thing, saying that
Yes.
COC shall record.
Yes.
Okay.
Yes,
Now
sir.
let's say on what will they record? You are giving your as a RP, we are giving our a compliance certificate.
Yes,
We are
yes, sir.
providing the 29A
Yes,
affidavit, everything.
yes, yes, sir.
Now question arises here:
Hmm.
what could the COC deliberate on? Now, if COC has a different point of view,
Mhm.
would they want the due diligence to be done again? Because they are talking about before the resolution plan is approved. I think it should come much earlier. This thing should come much earlier at the time when the resolution, before you declare a PRA, you are declaring the PRA based on the affidavit and whatever due diligence you are able to do, and you are saying that is the eligible party. Now, after having declared the party as a PRA, okay, and accepting a plan from him,
ठीक है.
then
Yes.
deliberating in the COC, to my mind, does not make any sense. Because it needs to be done before you declare a guy a PRA. Because PRA को आप तभी declare करेंगे ना when the person is 29A compliant and not merely on the affidavit.
Yes, sir.
So
Yes, sir.
I feel this needs to come somewhere else. Just a minute, please. Just a minute.
Just as a stop it.
Yes, sir.
Yeah. So
Yes.
as I was saying, now what will they record? And if they record, then why will it? Then it should also be voted that the COC agrees that this compliance certificate is in order, and they are satisfied. Uh, Merely recording without a vote or approval may not do the work, It's just like your.
So, sir, what your suggestion? Have to change in this regulation or something have required to be amended in this regulation?
No,
Something?
so what I
Yeah.
suggest, my
Yes.
suggestion is
Hmm.
that before the declaration of the PRA, okay, they
Yes.
should probably increase the time and say that the RP shall place before the COC all
Yes.
the POIs along with their due diligence report, whatever he has done, and that needs to be recorded by the COC, voted if required. Okay, maybe voted. And whichever the COC says, okay, we are satisfied with the reports of these 2-3 people, then then only you declare them as PRA. You declare someone as a PRA, then the PRA gives you a plan. Then you put the plan, and then you discuss about the 29A. I don't know what purpose it will serve other than just increasing one more meeting quite meaninglessly. Because the COC will say, boss, you have done the due diligence, we go by it. Today also that is exactly what is happening, no?
So basically, the word should, I think, the committee shall, before taking the means we can say something ki,
Declaring
after
the PRA.
declaring before declaring the PRA, take a not
Have a
not
decision.
take
Maybe
yes,
just to
yes,
add one
yes.
more caveat to it, of course, if it works for the COC are mostly the financial creditors. So when there are financial creditors, they will obviously know the status or the standing of any particular PRA with that particular PAN number or Aadhaar number or something. So if they have to give an inputs, they should actually be able to also state whether, he is not declared as an NPA or has not defaulted, because some of this information is there with the FCs also. So to a
Right.
certain extent, where the RP is limited, this information is readily available with the financial creditors or the financial institutions, as the case may be.
So the
To
so
add
so
on,
the suggestion So suggestion
that
is
is
that
or
it should
anyways,
happen before the declaration of
Please.
PRA.
Santanuji, that
Yes.
anyways is opportunity being given to COC member when you are declaring as provisional PRA and 5 days for objection if any. That opportunity is anyways given to the COC members before declaring them as final PRA.
So, sir, in that case, that is what I'm saying. Since you're doing that, why not have this meeting to record then and then declare the PRA? So if a COC, see, you have already declared someone a PRA. Okay. You shared, obviously you're sharing with the COC, these are the people and these are the documents they have given and this is the due diligence I have done.
Yes,
But
yes,
at
sir.
that point of time, nobody is saying anything. That is a practical situation, right?
Yes, sir.
Now,
So the committee
after
shall,
you have declared the person PRA
yes,
and accepting a plan, then later on you are discussing, that may create more problem.
yes,
Then
yes, sir.
what? So ideally, between these 5 days, maybe that 5 days can be increased to a little more. But have a COC meeting, present it. If the COC has some point, just like Madam Kanak was saying, that they would have some information about a party also, So
Credibility.
then you can then and there take a view, if there is some dissent or some point about PRA's eligibility, then you don't declare that person as a PRA, no? If the COC feels that way. So that is the way the COC will be responsible. So if you put the thing on the COC equally, then COC will in all probability even authorize that once you get a proper independent opinion too, for this due diligence done by some third party law firm or whatever, they can say
Yes, sir.
and so there you are actually putting a responsibility. Here you are it's a formality कि बाबा आप देख लेना.
So we will
Means-
say कि the committee shall before voting they should
No, not before voting, madam.
not,
Before declaring
before
the
declaring
PRA.
the PRA. So they should substitute this word, the before voting they should substitute here
No, be not
before
They
before
were
declaring
finalizing
Declaration.
the
They were
PRA.
finalizing the PRA list.
The PRA, yes.
So, ma'am, may I mention
Yes.
the one thing, ma'am?
Yes, yes.
Whatever Santanu sir has said, that's very correct. But we can
Yes.
interpret this provision first line. If you go to the first line, the
Yes, sir.
committee says before voting on the resolution plan. It
Yes.
is never said that at the time of voting of the resolution plan.
Mm,
So we
yes.
can always put this item for voting in before putting the voting for resolution. We can put one COC before also, I think.
No, sir. My point is, supposing you are declared a person as a PRA, XYZ party as a PRA, and he has submitted a resolution plan also, right? And after that, before putting the resolution plan, you are conducting a meeting and regarding this point. Now, something comes up. Somebody says,
Sir,
boss, this
sir,
is...
but because it is already mentioned कि how can they hold the meeting before before discussion on the resolution plan, because it is already mentioned here before voting on the resolution plan. So this event can also be occurred at the time of declaring the PRA.
This is what
Because,
I feel would be the proper thing to do.
Yes, it
Maybe
could be-
all
it could be.
PRAs may not put across their plans. So even if like it gets limited to the plans only, that can also be looked at. But basically, they should add something to the entire thing. Like it's not just 29 A's will officially come on an affidavit. Some compliances are also done by the RP. Ultimately, the COC should also add something to the whole
Something,
process, which
Rather
will,
than
give
merely
weightage.
recording.
Yes, some
Yes.
credibility
It
to
will
the
just
whole
become
process.
one more formality, nothing else.
No, it should
If
not.
at all
Otherwise, it's a
any...
formality. Absolutely. It's just a pair paper checking type of a thing, you know, if
29 days is
Yes, yes,
on
sir.
actual basis, actually 29 days. So I don't think a deliberation by the
it's
CIRP
an
members and
affidavit.
dissenting views on that. How can somebody dissenting views, somebody is eligible or not eligible? How can there be some dissenting views on
Be-
somebody's eligibility?
Because
ma'am.
ma'am, so many cases,
So,
there are
ma'am,
some
I
of,
have a
because,
suggestion. I have a
yes,
suggestion.
yes.
We can have this before considering a resolution plan for feasibility and viability.
Or
So
as
they
soon as
have
the
already
resolution plan
mentioned
is
before
received.
voting on the resolution
Before
plan, they have.
voting.
Madam,
Yes.
one
Yes.
legal point here. Supposing
Yes.
you have declared 4 people as PRA, okay?
Okay.
Because you have
Yes.
done your twin and A checking and all that, and you have declared them as a PRA.
Okay.
After that, supposing, let's say out of the 4, 3 gives you a plan. 3 gives a
Okay.
plan.
Okay.
Now, later on, you
Hmm.
come up with something and you say that this particular fellow who has given a plan is
Hmm.
not eligible under section 29A. It will lead to
Okay.
litigation.
Yes.
It will lead
Yes.
to further litigation. He
Yes.
will simply,
Yes.
why did you declare me as a PRA?
Yes. So you are saying that before voting on the resolution plan, they have mentioned, but they should mention before taking the final declaration
Before
on the
declaring
PRA.
PRA.
The PR. Before yeah.
If this has to be
Because
meaningful,
they can mention like this also before declaring the PRA and also before taking the voting on the resolution plan. Both can also be added here, I think so.
बोथ नहीं करिए,
Yeah.
बोथ मत करिए, आपको एक ही पे चलना है, या तो आपको ये करना है, या तो उनको बोलना है पीआरए के पहले ही आप ये मीटिंग कर लीजिए, because then only it is meaningful, then only it is some kind of then only is it's kind of, you know,
Because
some responsibility
Having
is put on the
value.
COC.
Basically, there's some value that can be put in the process.
Can I say something?
yes, sir.
We can
Yes.
say it as a to be deliberate before issuance of provisional list of PRAs.
Finalizing the final,
Yeah.
finalizing the
Before
PRA
provisional
list.
list.
When
Before
that
provisional
finding
list,
objection
sir,
has been put up.
Sucheta madam.
Yes.
Hello.
Yes, sir.
Can
Yes,
I
sir.
ask a question?
Yes,
How
sir.
many days we get to issue a provisional list of PRAs?
15 days, I think.
15 days.
Yes, yes.
Yes.
How many of we complete 29 due diligence in 15 days? Do you
I have
complete
always
it?
done it in
Yeah.
time.
Sir,
I have
so
always
many.
done it before time.
Yeah. Yes, sir.
But within 15 days? We suppose
Yes,
there are
sir.
10, suppose you get 20 PRAs, 10 PRAs. So you are able to do 29 within 10, 15 days.
Yeah. So what happens is, in my case, with the approval of the COC, I take help of some external agency too.
Everybody,
Okay.
everyone does it. You are not
So
unique
what
in it, everyone
happened?
does it.
Yeah. So
Shantanu ji, in
मैंने तो
90%
किया है
cases, just a minute. In 90% cases, when we issue list of PRA, it goes with a disclaimer that this PRA list is subject to further verifications of 29 eligibility.
Yes.
I do not know where from you people are coming. It's always go with a disclaimer. No, but
Fair enough.
hardly anybody completes a 29 purchase before issuing PRA list. Hardly anybody. And
So then what on what basis?
So, sir, what is your from your side? What suggestion? What
This is a good
suggestion
suggestion. What is there? Except that there are some extra part they need to delete it.
What
Sir,
what
may,
should be
may,
deleted?
may, may,
Yes.
may, may I share my view, sir?
Yes.
Actually,
Yes,
what,
sir.
what participants are sharing, they are right that practically, you see, it has to be discussed and deliberated upon before the issuance of PRA list. But the fact remains that in various cases, I think what one of the participant has mentioned that none of us do the or carry out the 29 due diligence. We simply rely on the affidavit submitted by the PRA. Because you see, one more aspect we must keep in mind,
Yes.
that assuming there are maybe 15 or 20 PRAs in the market, people charge depending on the quality of reports per PRA list, and sometimes it adds to the cost tremendously. So sometime RPs take a call that whether at this stage, let's go by the affidavit submitted by the 29A, not to commit further financial expenses. This is practical aspect I'm sharing. Legally, 36A clearly says that the resolution professional shall conduct due diligence based on the material. So legally, we are bound to do the due diligence. But this is also a fact that at that time, within a limited period of 15 days, it is not possible to carry out the due diligence by the RP. Or if he assigns the job to some consultant, he will also not do. Because they just do, they assign. Normally, my experience has been in many cases, when you outsource this kind of exercise, normally people have designated juniors to carry out the research online. That's it. And they combined the report and compiled it. That I have personal experience that I had to revert back to the concerned auditor or the outsourced person that you have not considered this, you have not considered this. Then they said, okay, I have not seen, my team must have done it. So these are practical difficulties. I think now coming back to the proposal, the discussion paper very clearly says that they want to create some kind of transparency and involvement of CSE also in this process. So of course there has to be some way, maybe it may not appear in the proposed regulation where the discussion paper says. Maybe it may come before the PRA related provision in the regulation. But the objective of this proposal is to involve COC in the deliberation.
My sir, COC
Yes, sir.
is already
Sir.
there in the
I have
delegation.
one suggestion.
The Supreme Court,
Yes, sir.
Supreme Court has clearly held in more than one cases that 29A eligibility cannot be decided by RP. RP job is only to conduct due diligence, place it before COC. COC takes the decision, and this gets recorded.
So
In
now,
more than, I have dealt more than 100
sir,
plans.
sir,
In
I'm
every
having
case,
some,
it gets recorded in the COC
sir,
meetings.
Sir, sorry to interrupt you because I'm having a limited time to discuss all the discussion paper. So
Madam,
now,
rest all are
yeah,
formality.
yeah.
This is the only
So,
part
so I think this is
This one is very
the
crucial.
best. Yeah, this is a best. I think this is the best in the favor of the RPs because first time something is deliberated on the COC. Which is specifically they will also be liable if something will be happened. So in my view, I think this is the best proposal, but they should make some draft format, standard formats for recording of this delegations.
One more suggestion
Yeah,
that the
yes, sir.
IBBI should come up with some the details of websites that should be gone through by the RP.
Yes, actually,
If the list are there, because the person who conducted 29A delegates, generally they gives the website they have visited. So they should visit those website too. It should be made available to all by the IBBI.
Okay, okay, sir. So the suggestions is noted here. Yes, sir, you want to say something?
yes,
Yes,
there
sir.
is no such specified list.
Sir, your mic is, I think some problem is there. Some noise is coming. So we'll go on the further second proposal. The discussion paper, the second proposal. This is the second proposal. Enhance the disclosure in the resolution plan regarding section 32A, basically. So we know that section 32A give the opportunity to the new RA to escape from all the liability, whatever is done prior to the CIR. So basically in PMLA also, they grant the liberty to the RA also. So why this proposal is here? The absence of adequate disclosure make it difficult to establish the identity of the potential beneficiaries under section 32A and undermines the spirit of law, the benefit of the clean slate principle, because by this section, the RA will got the clean slate principles under the IBC can only be availed if the condition laid down in section 32A are stringently fulfilled. So basically, we have seen so many cases, the petition have been filed by the PMLA against the RA. They are not eligible, and the benefit of this section cannot be granted to them. So basically, this new proposal was made by the IBBI. The ultimate beneficiaries of the successful resolution applicant must be disclosed in advance to uphold the integrity of the process and prevent any potential abuse. So what proposal will be fulfilled by the proposal number 2? The disclosure requirement. They have required the disclosure requirement regarding the beneficial owner. My screen is visible now, sir?
Yes, ma'am. Yes.
Okay. So what proposal will be fulfilled by the proposal number 2? The disclosure requirement regarding the beneficial ownership of the resolution applicant will enable the RP and COC to establish the identity of such potential beneficiaries. It also fosters the informed and transparent decision making that are ineligible or conflicted bidders, and ultimately enhance the integrity of the resolution process. So this is the purpose of the second proposal basically. Now the proposed solution. What is the proposed solution? Hence, it is proposed to amend Regulation 38 to mandate every prospective PRA to file as a part of the plan the following. Now it is required for the PRA they will file along with the plan the following things. What a statement of beneficial ownership, because so many disputed are there on which the NCLT have passed the decision. So in a format prescribed by the board, covering details of all natural person who ultimately owns and control the PRA together with the shareholding structure and jurisdiction of each intermediate entity, and an affidavit. First, they have required to file a statement of beneficial ownership, and second, an affidavit. The format is specified by the board, because for this purpose, the format will be specified by the board only, stating that the PRA is eligible, not eligible for the benefit of section 32A or not. So they have required to file these two things. Now, what is the draft proposal? Draft regulation is here. In regulation 38 of the principal regulation, after sub-regulation 3, the following sub-regulation shall be inserted, namely, what is the regulation inserted here? 3A. Every resolution plan shall include, first, a statement of beneficial ownership in the format specified by the board. So board will specify this format, covering the details of all natural persons who ultimately owns or control the resolution applicant together with the shareholding structure and jurisdiction of each intermediate entity, and an affidavit in the format is specified by the board that the resolution applicant is eligible, not eligible for the benefit of section 32A. So basically, these two documents required to be submitted by the PRA, and the format will be specified by the board only. So we have no knowledge about the format, what will be the format in future. So ultimately, these two things have to be required to be submitted. Now, what is my suggestion is here only. Require the resolution applicant to update the beneficial ownership statement if any changes occurs between the plan submission, and because if we have submitted the plan today, but after 2 years, after passing of 2 years, the plan was approved by the adjudicating authority, then what will be the status of the RA at that time? So I have a suggestion. He required the resolution applicant to update the beneficial ownership statement if any changes occur between the plan submission and plan approval by the adjudicating authority, because we all know 2 years or 2 to 3 years will take by the adjudicating authority in approval of the resolution plan. So this required to be, this has to be added here. Now, the beneficial ownership statement would be updated on the IBBI electronic platform, because this have required to be updated on the IBBI electronic platform and accessible to the COC member for the transparency. So these two proposals is from my side. Now, I invite all the participants, they can share their own views.
Madam, this is a very
Yes.
good
Yes.
regulation.
Yes.
Only thing is,
Yes.
anyway, when they are giving this affidavit along with the plan, you know,
Yes, sir. Yes.
you are going to submit the affidavit to the COC,
Yes, sir.
from the along with the plan itself, right? Because you will have to
Yes.
put the whole and
Yes,
your
sir.
compliance certificate before the maybe they will amend the form H also to that extent that will finally sign before the NCLT. So publishing it on the IBBI website may not be that great a thing unless you also publish everything else on the IBBI website. You know, who are the PRAs and whatever these things.
Okay.
So this is okay. Require the resolution
Okay.
applicant to update the beneficial ownership
Yes.
change and all
Yes.
that. That is perfect. Yes.
Okay.
The second part may not be this thing. Otherwise, this is a very sound
Okay.
proposition.
Okay. Okay.
As a matter
Okay.
of fact, now if you read both of them, one
Yes,
after
sir.
the other, then it makes
Yes.
sense. Because then before the formally voting the COC, you can place both the 29A and this before the
Okay.
COC and that they have also given this thing. This is the ultimate beneficiary, and there maybe the COC may know someone who is the ultimate beneficiary,
Yes.
and they can give some inputs. No, ये बंदा तो इसके साथ related है or something like that, So these two now make sense. Reading them together.
Okay. So the other participants, if they want to say something on
Yeah,
this.
if there's any
Yes.
change in the beneficial ownership after the plan approved by the COC and
Yes.
the approved by the adjudicating authority, will it go back to the COC members? What is the right with the COC members to be done? What action you can take with this change because the plan has been approved by them. It is already pending with the NCLT now. So if some change happens, then there are many more complications there. Will it go back to COC member that this changes happen now? Still they want to approve the plan or not? Or I don't understand the reasons. There is any change.
What
Just
Because
happens
put down
if
before the
yeah,
NCLT or this for the decision making. They again have to decide on the plan.
suppose ma'am, if the plan is already pending before the NCLT and it will take more than 2 years.
Yeah, I understand.
But today I'm not the shareholder of this company, but tomorrow I am the shareholder of this company, which is in which I am having some beneficial owner or whatever, and this will impact our eligibility as per section 32A. So in that case, how if the plan was approved and then some petition will be filed by some other petitioners. He
No, I
was
got
not
your
the
point.
yeah
What I'm
yeah
saying is,
yeah.
if there is such change, will it go back to COC for discussion? Because
Yeah,
since
will it be
the
remanded?
ownership
In
has
fact,
changed,
in fact, if the beneficial ownership now reveals that somebody is disqualified
Because-
after, say,
because
1.5 years'
as-
time, before the A approves it, will the
So
entire
you
process
are
be remanded and again
saying, yeah.
revisited? One thing. Second thing is some of high value plans. Sometimes they say that there'll be people who will be joining them or people will be consenting them at a later point in time. So in that case, obviously the beneficial ownership, the ultimate beneficial owner is not sometimes known. So will that be the case that anything will not be an open-ended statement anymore? So suppose there's going to be some financial institution backing them, and the institution also will obviously be the beneficial interest, having beneficial interest is on
So
both.
you are saying the resolution applicant, if there is any change in the beneficial ownership,
Yes,
they
when
will
FI
go.
changes,
They
yeah.
will go to the COC first, and then COC will make the decision and will submit to the NCL, whatever.
And there will
we
be
should go
two.
to COC members first for their information.
Yeah.
Sorry, ma'am?
Yes, ma'am.
See, what happens is suppose there's an FI, financial institution, which is joined along with the PRA for funding this kind of a plan or a proposition. And obviously, at that point in time, they're all qualified. The COC has approved it. Before the AA approval, if there's a change of the financial institution which is backing this particular PRA, then in that case, the beneficial ownership is going to undergo a change. If that beneficial ownership undergoes a change and this new person is not eligible, or at any point in time, the earlier beneficial owner also gets ineligible in the process because he may have actually participated in some other process and may have got disqualified for whatever reasons. In that situation, what happens? Okay, 32A is basically only if I mistake not, it is with regards to PMLA transactions.
Yes, basically, no, not only the PMLA transactions, there are so many benefits have been given through this section.
So all the tax liabilities will get,
so,
reduced, nullified.
So I'm saying कि if required, the resolution applicant to update the beneficial ownership statement if any change occurs between the plan submission and plan approval by the adjudicating authority to the COC. You are saying to the COC first, no?
Absolutely. And there should be definition of the beneficial ownership also, because it varies under the various acts, in the country. As UBO, there are different percentage hold that defines, companies that say something else, banks have their own. So what is beneficial ownership? What percent of change will amount to change in beneficial ownership? This also needs some clarity, actually.
And also the COC members, they do not really hold a position once the plan is put forward to the AA. So they do not, even if they exist, they per se are not the decision makers at that point in time once the plan is put forward to the AA for approval. So they cannot take decisions.
Probably AA will, remit it back to the COC. If some changes implemented the AA, then the NCLT will remit back to the COC members. Probably, that you may reconsider it to that extent of that. This could be, and then I don't know what will happen again. Form G will publish, or what will happen if they don't.
So something has to be, something has to be the result out of it.
Understood.
It just cannot be that, somebody gets disqualified, because what happens sometimes the beneficial ownership will be the erstwhile promoters only, who have already defaulted on various acts and now are going to come take a backdoor entry and take the company back. So beneficial ownership at one point in time did not show them as the beneficial owners when the plan was being approved. But post the plan is approved by the COC, automatically there's a change in the structure itself, for funding. Then what happens? Will the PRA really come forward and say that, okay, fine, the person who was funding me earlier is not doing it anymore and now we've got a new ownership? And if the A approves it, post which again the same old owners, are going to take forward the company.
Madam,
sir,
can I submit something?
Yes, sir.
I feel what you are saying require the resolution applicant to update the beneficial ownership is correct, because supposing there is a change in the ownership, and let's say someone ineligible comes in later on through the back door, as was being said, it must be reported to the adjudicating authority at least.
Yes, sir.
Okay.
So the benefits will not be passed on to the same old people.
Yeah, so that the 32A benefits don't get passed on to the old guy,
And
if this is kept like that,
Yes, sir.
मेरा experience यही रहा है, sir. Actually, this is a big problem happening in most of the MSEB cases of CIRPs. Now, people are planning CIRP with a deliberate plan, structured way. So what they are doing, there are people in the market who enter into understanding with the promoters that maybe after this, during the CRP, we will bid for your behalf, and this is the cost. And then there is an understanding that once the resolution plan is approved, that the CD is handed over back to the same old people. So I think the objective is to caution on to bring certain things on record, that so that the concerned authorities, not the COC
Yeah.
or the
Yeah.
adjudicator, they can take appropriate action in due course of time whenever such things come. For example, in many cases, there is a large scale manipulation and fraud of GST. In one of the cases I am handling, there is a huge GST manipulation, there are arrests and all those things. What happens? And that person, assuming takes back the CD after all these 32A benefits. So the entire liabilities of GST department will suffer, income tax department will suffer. So I think the proposal of this proposal is basically to bring on record that this is the ownership when the resolution plan was approved. That's it.
Yes.
And if there is any subsequent change, now it is for the respective authorities in future to go and challenge and catch the culprit. Ki, look, you came through back door or something like that. This is, I think, is the objective. Now we have to, because we people are dealing with all these kinds of practical issues. Now we should suggest how these misuses can be prevented. The objective is to prevent the misuse.
So, sir, you are saying that this, whatever is drafted, the new draft regulation is okay, or you want to add something, or the suggestion is not okay?
No, suggestion is very good, but my I am not able to comment on how effectively we will be able to use this, because you know what happens,
Because
there has to be some limit of change in beneficial owners, because this will create litigation,
Yeah, this
maybe
has
at
to be
a
firmed
later
up.
stage.
Definition has to be there for the BO, what is BO, what change will amount to the change in the beneficial. The some definition has to be linked to this regulation.
So I think there is bent to form or something in the Companies Act. So they should also link with this. So the directly they have known from the MCA, because MCA and NCLT and IBBI all are connected. So there should be something from this type of arrangement should be formed from the IBBI side.
Or maybe they should not be
Yeah,
allowed to, change the beneficial ownership at a
So
later
we'll
point in
because
time.
the limited time, we'll go on the third proposal now. The third proposal is there. The invitation and submission of the resolution plan through electronic platform. So why this proposal number 3? The success of platform in digitalization of liquidation process present a compelling case for extending the similar technological issues solution to other aspect of the insolvency proceedings. So 10th report of the Standard Committee of Finance on demands for grants of the Ministry of Corporate Affairs has recommended that the MCA implement the direct submission system for the resolution plan through the central online portal. So this submission was made by the MCA, and further supporting this direction, the IBBI study group report, they have also made some submission. Developing the market for stress assets in India, released in May 2025, noted that the currently IBBI portal, as mentioned above, cater to the listing and e-auction under the liquidation process. However, to be more effective in removing the information asymmetry during the resolution process, a preferred method would be for the resolution proposals to also be listed on the IBBI portal. So this was a proposal made by the IBBI study group and also made by the MCA committee. So what purpose to be fulfilled with this proposal? So there is a pressing need of the digitalize the resolution plan receipt process to maintain the fairness, transparency, and efficiency in the resolution framework while ensuring the confidentiality of the sensitive commercial information. So this is basically the purpose. Now, proposed solution they have suggested, based on the demonstrated success of the digital platform of liquidation process, preliminary committee recommendations and IBBI study group findings, they have proposed to amend the CIRP regulation to empower the board to notify an online portal for activities in relation to invitation and submission of the resolution plan, thereby extending the digitalization benefits currently realized in liquidation processes to the broader resolution framework. So basically, this is basically the proposed solution. Now, I will read the draft regulation. So what is drafted by the IBBI here? After regulation 36A, the following regulation shall be inserted, namely 36AA. Invitation and submission of the resolution plan through electronic platform. The board may, by circular and with effect from such date as specified therein, mandate that any activity in relation to the invitation and submission of the resolution plan shall be carried out exclusively through an electronic platform recognized by the board. So basically, this was the draft regulation which was proposed by the IBBI. And if there is any suggestion from the participant side, they can suggest. But I have not make any suggestion here because from my side there is no such suggestion. So I inviting all the participants, they can share if they have any suggestion.
Usually all plans are different. So I'm not sure if anything can be standardized on that count. Every asset is different, every corporate is different, values are different, requirements are different. How will we be able to standardize anything on the platform? Even if the platform is anything is uploaded as it is, it's the same old story that we get, we need to get a hard copy end of the day because that has to be submitted, that is taken as a final copy for, all legal purposes also.
So you are saying,
but
yes, sir.
I think this is a very good proposal.
Yes, sir.
Because
Yes,
we
sir.
come across a lot of problems and people have now become expert in derailing the process. They will send khali lifafa, they will send some documents, some they will not send, some will hold the documents and then send subsequently. These tactics they are adopting and they are becoming expert every day. So I think digitization will ensure some kind of transparency where RP can simply say that you upload the document and then I'll download or save in the file. That is up to us. And after that, the window can be closed maybe on the designated day. Because I have experienced that some people kept on insisting to the COC, please extend for by 6 p.m. by at p.m. I have not sent it. Sometimes they have not sent the draft and they send the documents. All these things happen. So I think this may smoothen or facilitate our life for easier working, I think.
Yes, yes, sir. I am also agree with you. And the other
This is a
participants.
good proposal.
Yes,
This is a good
yes.
proposal. I have been
Yes.
using this IBBI platform for anyway. Most of us who are in liquidation would have used it by now. It's a good platform. They are changing also gradually. They're improving. Only thing is that we will have to see what format these things they are going to when they're talking about standardization, how they are developing the thing. In a liquidation, you are just listing the asset. People are showing their interest and they're paying the EMD through the wallet and all that. Okay.
Yes.
Now,
Sir.
in this, are they also going to say that, let's say, if your EMD, let us say your EMD after the approval of the plan by COC is, say, 1 crore rupees or XYZ.
So later on, this have to be discussed because we have no idea what type of platform they will create.
ये proposal तो अच्छा है. It's a very good proposal. At least if they're doing it electronically, the trail is there. And thankfully, it takes off some headache from our head also.
Yes,
You have given it in the platform and I don't know. We can.
Yes, sir. So now I think we will close this discussion on this discussion paper. Now I will share the other discussion paper, which is also sent by the IBBI. So I'm just sharing 1 minute. So my screen is visible. Can
Yes.
you see the discussion paper, 12th August 2025? This is the discussion paper. I was not made any PPT for this because the single point is there. And this is very relevant point for us as a IP. So the discussion paper is on the review of the limit of the number of assignments being handled by the IPs. So what is basically covered here? The discussion paper seeks to examine and address the concern relating to the delay in insolvency and liquidation process, and concentrating the assignment among the few insolvency professionals as highlighted by the IPs during the stakeholder consultations at various forums. So it proposed to amend to applicable regulation with the objective of ensuring a more equitable distribution of assignment and enhancing the overall efficiency and mitigating the risk of handling the insolvency assignment by a limited number of insolvency professionals. So basically for this purpose, they have sent this discussion paper. So what is the, basically we will see what is the introduction they have made here. The IBC was enacted to provide a time-bound mechanism for the resolution of financially distressed debtor with the objective of maximization the value of their assets. It marked a decisive shift from the traditional recovery-oriented mechanism to a comprehensive framework focused on a revival, resolution, and the recognition of the distressed debtor. So one of the definition feature that set the code apart from its proceedings is its emphasis on the time-bound processes, ensuring the greater periodicity, efficiency, and the value preservation. So code seeks to maximize the value of assets of the CD. This is basically the objective of this IBC. And recognizing that the value is the time sensitive and delays in the resolution process tend to erode the value. So basically this is the introduction they have given. Now what is the existing framework? We will see. Key to ensure the efficient conduct of the processes and safeguarding the equality of insolvency resolution, clause 22 of the code of conduct, because we have already having some code of conduct. I will also show you this code of conduct, which is specified in first schedule with the IBBI Professional Regulation 2016, which imposed a restriction on the 10 assignment as the RP in a corporate insolvency resolution process, of which not more than 3 shall have admitted claim exceeding 1,000 crore rupees each. This measure was introduced in July 2021 with the aim to ensure the IPs do not overstress their capacity and are able to develop adequate time and attention to such each assignment. So basically, this is the regulation. Let me just show you. So I have now.
You know what?
1 minute, sir. I just complete the regulation and this, then we will discuss, sir, everything. So basically what is mentioned here for IP regulation, first schedule. So this is the first schedule and here is the 22. They have already mentioned earlier an insolvency professional must refrain from accepting too many assignments if he is unlikely to be able to devote adequate time to each of his assignments. And clarification is also there. An IP may at any point of time not have more than 10 assignments as a resolution professional in CIRP, of which not more than 3 shall have admitted claim exceeding 1,000 crore rupee each. So basically, they have something earlier also, but nobody have followed these kind of code of conducts. So some IPs is having more than 10 assignments. So they have now make a specific regulation for this, which I'm sharing. need. What is the need? Basically, we should know why there is a need of this this discussion paper. So the code allows the IPs to undertake assignment in multiple capacities such as IRP and RP in CIRP, liquidator in liquidation or voluntary liquidation process, and RP in PG to CD, etc. So considering that time is the essence of the code, the clause 13 of the Code of Conduct of IP regulation provide that IP must adhere to the time limit specified in the code and the rules, regulations, and guidelines thereunder for the insolvency resolution, liquidation, and bankruptcy process is the case may be, and must carefully plan his action and promptly communicate with all the stakeholders involved for the timely discharge of his duties. While the Code of Conduct of IPs, as stipulated under the IP regulations, require that an IP must refrain from accepting too many assignments if they are unlikely to be able to devote adequate time to each. There is currently no specific cap on the number of assignments on the IP may undertake as a RP liquidator or RP bankruptcy trustee in proceeding against the PG to CD. So the only express cap applies to assignment as RP in CIRPs. However, the absence of similar restriction on other critical roles has substantially diluted so effectiveness of this cap, since many IPs continue to be involved in multiple assignments under other capacities simultaneously along with their regular professional practice. So as per the information available on 31st March 2025, there were 4,527 IPs registered with the board, out of which 2,198, means 49%, were holding AFA issued by their IPM. And while the Code of Conduct advised IPs to avoid excessive caseload, the absence of the express limit on the role such as IRP or liquidator has also led to significant disparity in the assignment distribution. Feedback from the shareholders and analysis of the assignment data show that a small group of IPs handle a disappropriately large number of assignment up to 25 in the same cases, in some cases. So raising concern about the quality of the resolution, inclusiveness, and equitable opportunities for new IPs. So such concentration is perceived as a concentrating factor in wider participation of IPs, posing challenges to inclusiveness and transparency within the overall insolvency economy of the country. So this kind of report has been given by the IBBI, how many IPs are there, how many having the AFA, and how many having more than 25 and more assignments. Now, what is the proposal basically? The rationalization of assignment limit for the insolvency professionals, encompassing the interim resolution professionals and liquidators through the deletion of the Code of the Conduct clause 22 and insertion of new regulations. So they are saying we are having the Code of Conduct as per schedule 22, but we want to now we will delete this Code of Conduct, but we will insert a new regulation because regulation will be fulfilled by mandatorily will be fulfilled because Code of Conduct was not fulfilled by the IPs. So they introduced there should be a new regulation which can be enforced. So this Code of Conduct can be fulfilled. To address this, it is proposed that the existing assignment ceiling of 10 assignments in the capacity of RP shall also be extended to include the assignment undertaking in the capacity of IRP and liquidator, of which no more than 3 shall involve admitted claim exceeding 1,000 crore. Furthermore, the IPs who are already handling 10 or more such assignments, whether in the capacity of RP, IRP, or liquidator at the time of implementation of this revised framework, shall not be eligible to accept any new assignment until the number of their ongoing assignment falls below the revised threshold. So only those IPs who are handling fewer than 10 such assignments, whether as IRP, RP, liquidator will be eligible to take up the new assignment subject to the compliance of the revised limit. So this was the proposal. Now, how they have incorporated in a regulation. So I will also show you that they have inserted a new regulation 7B on the number of assignments. So what is provided as per this 7B? The IP who is not an insolvency professional entity shall at any point of time have not more than 10 assignment in aggregate as a IRP, RP in a corporate insolvency resolution process and as a liquidator in a liquidation process, of which not more than 3 assignments shall have admitted claim exceeding 1,000 crore rupee each. Explanation they have also inserted here. An IP who at the on the date of the commencement of the Insolvency and Bankruptcy Board of India amended regulation, this is handling 10 or more such assignments shall not be eligible to accept any new such assignment until the number of his ongoing assignment fall below the limit specified in the regulation. So basically they have inserted this regulation. I have made some suggestion here. The suggestion is that I'm okay with this, but I want the list of empanelment because I have seen the final list. The final list of the IPs now downloaded on not downloaded. So I have seen the empanelment list of the IBBI. There are the name of the IPs already included in this empanelment list who is having more than 10 or 12 assignments. So my suggestion is there the list of empanelment of the Insolvency and Bankruptcy Board of India and any empanelment prepared separately by bank or other financial institutions shall not include the name of the IP who is already ongoing 10 such ongoing assignments in aggregate or more than 3 such assignment having admitted claims exceeding 1,000 crores rupee each. So this is only my suggestion. Now I'm request to all the participants, they can provide their own suggestions. Yes. Yes. Yes, sir. Yes.
So, Ma'am Arun Gupta this side. Yes, this is like if you see the objective of the such limitation and restriction, this seems logical. This seems logical to include an IRP and liquidation also. But if we see it, I saw there are two things which either they missed it or they deliberately did it. I just wanted to bring that into it. One is that practically one thing may create. So one is that I'm not sure whether voluntary liquidation is covered into this, because in the whole discussion paper they talked about distress assets, work, cumbersome and work, a lot of other duties which somebody has to fulfill. Because the duty of a IP in a voluntary liquidation assignment, yes, obviously they have to fulfill the whole assignment, but the workload is too less in comparison to a liquidation. And the whole discussion paper is talking about liquidation and CIRP, liquidation and CIRP. But when you see the proposed regulation, it is using the word liquidator.
Yes, sir. Yes, sir.
So it will then interpretation could be liquidator as a voluntary liquidator or a liquidator. I think both should include as per the present regulation. But my suggestion is that it should be excluded because voluntary liquidation is more about just making the payment to the shareholders after payment of liabilities. There are no third party stakes involved into it, and those are solvent companies, not distressed assets. So those should not become part of such restrictions or limitations. This is one, because they have expressly excluded the PG RP.
Yes, they have not covered the PG cases. They have not covered.
Maybe VL liquidator is also not the intent of the IBBI, but as per language, it is coming as inclusive.
Yeah, so there should be some clarity on the language whether they have covered the voluntary liquidation or not. Yeah.
One is that clarity, and second is that as a suggestion.
They should exclude this. And the
second suggestion.
Yes.
Sorry to interrupt. And the second suggestion.
Yes.
Even as a liquidation, if you see for a liquidation under section 33, which is as per the order of the NCLT, or under 59, which is a voluntary liquidation, in all such, so for example, there is an IP who has said 10 assignments. Out of those 10, maybe 5 resolution applications are pending in NCA. And resolution application might take, say, 2 years, 3 years. It takes kind of timeline also. But when a resolution application is filed, the role of the liquidator is just to attend the hearings. Nothing else happen except some bit of small things, because the process is over. The liquidation process is over. Just the application is pending for final order. So that should also be excluded while counting it, because somebody will otherwise carry this number because a resolution application is pending. Practically,
It's a very good suggestion. It's a very good
be
suggestion.
harsh.
This
Harsh
applies
very
to
good
CIRP.
suggestion.
because
This applies
nobody
to
can
CIRP
control the
cases
time
also.
of NCA.
This applies to CIRP cases also. Sometimes plan approved by the COC CIRP process completed and the NCLT is taking years to complete that.
Yes, yes, yes.
Assignment.
So
the-
at this point of time, they will exclude everything with the voluntary liquidation excluded, the dissolution liquidation pending, they will also be excluded. And after that, if we will say ki, the resolution plan is already pending for approval, they will also be excluded. So everyone asks their own demand, na, sir, at that time. So there should
There
be
can be some
some
sub-limits as well. There can be some
yes,
sub-limits.
yes,
The
sir.
cases
Yes, sir.
where the CIRP process has been completed by the IRP and RP and this is pending for the NCLT, they can have some sub-limits as well, because as rightly said, the cases which have been handled by the RP and placed before the NCLT, they are taking 6 to 7 years to conclude and approve the resolution plan.
Yes,
Many.
yes, sir.
So in this way,
Yes.
the RP, who is actually capable of handling much more assignment, won't be able to accept it because their plan is pending.
More than that, they are not even paid in that duration at times.
Yeah, that's the better part. That's the worst part of it. They're not even paid.
So how many assignments are paying you in that duration is equally important.
That's why.
As a matter of fact,
date of completion of CIRP is nowhere defined. The loss is 300 days, to complete. But what is the date of completion? Is it plan approved by the COC or plan approved by the NCLT? This is always a debatable issue.
And ma'am,
there is one
So
more.
I say it differently.
Yes.
You may take period of 330 days for CIRP. For more than that, CIRP should be excluded. And for liquidation, it is 1 year. Post 1 year, that should be excluded from the bracket of that IP.
See, one more thing
Yes,
here. What
yes,
happens,
yes,
if you see the new amendment which is proposed, okay, the proposed amendment to the Act, right? They're talking about a group insolvency also, where they're saying one insolvency professional, which could, in all probability, maybe an IP acting as a IP, okay, be appointed as a RP for the entire group, right? Now, this 1,000 crore, let's say Videocon kind of a case. उसमें तो हर एक सब्सिडरी के ऊपर हजार करोड़ के क्लेम आएंगे. And in one of my cases, in liquidation, every subsidiary's claim has been added to the, because there are cross guarantees, Okay. So everything is above 1,000 crores. The parent is having a total claim of 30,000 crore. What to do?
So, sir,
that would make
the verification, the time in verification of the claim is also be consumed now. If these such huge claims are there, so
Yes.
how the IP, if they will get more assignments, so then how can they will handle if there is a
Madam.
Yes, sir. Yes.
All the claims that you get, you have to adjudicate within 30 days, right? You get
Yes.
30 days to get the claim, another 30 days to adjudicate. After that, your claim verification is over. You don't need to.
But sir, practically.
Hold on.
this
Can
is-
I?
Yes.
Yeah. So it is claim verification duty under liquidation is over once you have got crossed that, because only modification can be done with the leave of the court, right? In the stakeholder list. And now let's look at it this way. There are many cases. At least in my case, I will tell you, I have sold all the assets. I have already distributed the money. But what is pending is a PUFE or some other litigation, because of which I am not able to dissolve the company. Because it's not going under NRRA. Now, of course, I am without pay because I am still a liquidator. I am not able to dissolve the company. In one of my cases, I have filed a dissolution application 3 years. And all of a sudden, GST department gets up and files a claim before the NCLT. After I have filed the dissolution application, closed all the account, and the NCLT is entertaining it and not passing my dissolution order. That is my fault. So these things have to be looked at by IBBI rather than just looking at some statistics. Kya raha actually? People are saying some people have multiple assignments. Yes, right. The reason they have multiple assignment is because they have demonstrated their capability of handling. Nobody got 10 assignments on the first day. I have been a IP from
That's what I wanted to add.
Yes,
That's
sir.
what I
Yes,
wanted
sir.
to add, ma'am.
Got it, sir.
Why IBBI is, as a regulator, need
why
to
is he getting
equate
involved
the
into all
number
this?
of assignments among the IP? Because it's all about ecosystem of the market. Whosoever is working, obviously, somebody is giving an assignment will obviously do the due diligence. Yes, their role is to see that there should be sufficient time and effort to be put in on the assignments. I'm not denying.
As a matter of fact, most of the banks have a regulation now. If you have more than 3 assignments, they're not even considering you.
Yeah,
I have not
that's
taken
fine.
an assignment for such a long time.
That
I am
is
invalid
also
with all
But sir,
by the
but
market.
sir, if we will see the, if I will show you the empanelment list, what is finalized by the IBBI in these days. In this list, we will see so many people are having more than 25 and more than 25 assignments.
Madam, but
So,
they are
yes,
supposed to be given lower priority. If you see the weightage, they have a weightage also, no? So whenever I apply, I don't apply to be on that list anymore. I don't apply at all to be on that list anymore.
Yes,
But
sir.
my weightage is 0.
Hello.
Yes, sir. Yes,
हाँ,
sir.
बोलिए,
Yes, sir.
बोलिए।
Please share, sir. Share.
But sir, actually, क्या madam, ये 10 assignment is too much for the IP or RP because he is not able to handle the one company if it is a going concern. Okay. Or the second thing, IBBI should insert this PG, the personal guarantor also in this 10 list. Okay. If they get the 10 managing director is not able to one company, the IP should the 10 company. It is foolish things. It is not practical. If you will see how many cases going on the RP.
So you are saying the practically they should also include the PG cases here also.
Yes, because if you see the so many.
But PG cases, there are very few
Madam,
amounts have been
Madam,
given to the RPs.
Madam, it is
Yes.
the RP who will choose. I have to be take this personal guarantor case or not. It is if it is very sure that I am very capable. So look for the big assignment. Why he is going for the IBBI should consider also this. They need some time to do this personal guarantor also. Have you see the list of the in impanelment? There is no case for one case of the IP. What
Yes,
is the
sir.
benefit?
Yes, sir. So I'm saying
If you will
some
not,
of the IPs are having more than 10
madam,
10
madam,
assignments, but some of them,
no,
I will show you, sir. I will show you this list
madam,
also.
it should
Yes,
be
sir.
not 5 cases
Hey,
is sufficient for
ongoing.
a RP.
Yes, sir.
5 cases is sufficient only for RP, no
Yes.
10.
So I'm saying
Completely
still
agree.
the
Completely agree. There are
Exactly.
30 days in a month. There are 30 days in a month. Even if you give 5 days in per assignment, it is 25 days. So 5 days. So 5
Yes.
assignment. But that should exclude this after filing this the resolution plan or resolution application or this that should be excluded.
Yes,
So
that's
that
very
should that should be
As an RP
Okay,
or
I have already noted here, sir. What should be excluded? I have written here. So
but it should be the number should be reduced to 5. That is what we are
exactly.
suggesting.
We are
Because even in
we are
5 days
handling an
RP
organization.
in work per assignment, it will be 25 days. So 25 days is enough.
But
5
sir,
assignment is enough,
but
but
sir,
that should be.
One madam.
yes,
One
sir, but
madam.
Resolution
one thing.
plan, resolution
Hello?
plan, resolution application, and
Yes.
Hello?
Yes,
Hello?
sir.
Madam,
Want
I
to
want
say.
to add, madam, I want one thing more.
Yes.
Hello?
हाँ बताइए sir.
Madam, if you see, the IP is a professional company secretary, he is a lawyer, he is a kind of post accountant, he is a
Yes.
management. He don't have other work. To whom they are making fool? I will take 10 case, can case. Their valuer is there. They don't have other work. They don't have any taxation work. They have so many works,
Yes,
excluding this one.
as an RP, you are handling an organization single-handedly, which was being handled by the entire board and the KMP, coupled with many employees. And then you 10 and 20 cases. How can you justify your time? How can you justify the job? Where
So
do
you.
you get the time from?
So can I make a submission here?
Yes, sir. Yes, sir. Yes.
hello.
Yeah.
Because,
Can I make a
because
submission?
these
I have-
assignments are being taken by the few IPs as already
Hello.
written in the discussion paper, and there is hand and gloves is going on.
I have another submission, ma'am.
Yes, sir.
Where we are looking, everywhere we are looking that there should not be any interested party. Why the bankers should give a list of and appoint and nominate an RP or IRP
Sir,
from them?
I already raised this issue before the IBBI, and I was already sent a letter to the chairman of sir also. So I have discussed so
So,
many times
can
why the separate empanelment will be permitted to the banks and the financial institutions, because by
Exactly.
this way,
Can I
Madam,
just
sir. Yes,
Can I
yes,
have
yes,
submit?
Madam,
yes,
madam, actually,
They
madam,
have got the list.
one thing I
No,
want to
madam,
add,
but
madam,
that empanelment is for 3
excuse,
years. So how can you
hello,
exclude anyone for 3 years?
hello,
Sir,
madam,
sir,
This
if
is not.
already having the empanelment with the IBBI, and IBBI
madam,
in every 6 months have made the
IBBI has
empanelment.
impaneled. Then why second
Yeah,
impanelment?
yeah. Why
That is
the
a related
second?
party again. You
Yeah.
will be under the control of the
No,
bankers.
Yes,
Can
yes,
I,
sir.
can I, can
Yeah.
I,
Yes, yes, sir.
Yeah.
Please
excuse
submit, sir.
me,
Yes,
excuse
please
me, can I
submit.
now submit?
Yes, sir.
Okay.
Submit.
Okay, now it's like this. You have one provision that the COC can change a IRP or a RP at any time without assigning a reason. Hold on. Okay? So let's say now you're saying ki just because I have become a IP, I deserve work. And no
So
other.
I think,
One
so
second,
I
hold
think
on,
this,
hold on, madam. I have heard you.
Yes.
Hold on, I have heard you. Okay, you're saying that I
sir,
have
you
become
are
an
reading
IP and
from 1 to 1 hours.
I have I deserve work. I should get it turn by turn or whatever you may say. But the moment if you are not you're wanting work without licensing, without proving your metal before the COC, the bankers, whoever gives you this thing, you need to go and get work. You will not, the work will not come to you on a platter. If you have credibility, if you are a professional, if you are a seasoned CA, or if you have an industry professional, you're an ex-banker, you will get work.
The job of
So
RP,
I'm saying,
the job of
if
RP liquidator is
madam,
not
why only
madam,
my concern is
actually,
that
madam,
why there is a
to get
separate
the job.
empanelment is there.
madam,
If already, because there are so many formalities are involved in the separate empanelment with the bank. Suppose if the SBI have recently issued the circular for the new empanelment of the IPs, so we have required to make so many formalities. We have required to submit so many documents so many times
madam,
before the banks.
madam,
So why there is these type of things is there?
No, second thing,
actually,
what
madam,
he is
Yeah.
suggesting.
actually, madam,
Yes, yes, sir.
Madam,
Yes, sir.
suppose I am sitting on a bench, player is
Yes.
playing in the football match, so
Yes.
I will show my capability to the people when I am sitting in the
Yes.
bench.
Yes. Yes, sir.
So why they making the
Yes,
fool
sir.
to the
Are you
people?
a fresher? Are you a fresher or you are having
No,
20 years
no,
of
no,
experience?
ma'am,
I am not. I
another,
am seeing the.
no, ma'am,
I
So
am
if
another
you
seeing the
have
total.
15, 20 years of experience or you have
Sir,
practiced,
please.
you would
everyone,
be.
I
sir,
think this
everyone is
discussion is going on 1-to-1 now. 3-4 people are starting. This is not good. I think this is not going a good discussion.
Madam,
The
madam, can I share?
the
Can I share?
only thing
Can I
is time and
share?
effort.
Yes, sir.
Nice
Yes.
suggestion
Only
here.
thing
Madam,
is time
Yes,
and
sir.
effort.
Please, sir. Please, sir.
Ma'am, I
madam,
think you should
One
take
by
suggestion
one,
from
sir.
everyone, ma'am.
One
yeah,
by one,
yeah,
sir.
Let's
madam,
allow
madam,
everyone to speak,
Sir,
ma'am.
yes, sir.
madam,
Because
Ma'am,
we have
please
required to discuss.
take the written suggestions. That will be better. Actually.
Yes,
madam,
yes, sir. Please, in
one thing I
writing.
want to,
Yeah.
Ma'am,
I want to
please
mention
ask
that
other guys to, not to comment on the other IPs, because people are, here commenting on other IPs stating that they have a lot of cases and all. That is not right, because it will go in wrong direction.
Yes. Yes, yes,
So I
sir.
will request you to
So,
please tell the other people.
we will not commenting anyone. We will only include ki what should be included in this regulation and what should not be included in this regulation. That's
Exactly,
all.
ma'am.
So,
Madam,
what should be added here? Only the specific have to told me ki what should be specifically added here or not.
Ma'am,
added.
will
madam,
the
Or
in
insolvency,
this connection,
will the
in this connection, madam, I
Yes,
would
sir.
like to
Yes, sir.
submit
One by
that the
one, sir.
proposal is,
May I say something?
I think the proposal is in the right direction, and
Yes.
they have explained in detail the objective of this proposal. I think they want to limit, they have more experience than anyone of individually may have. So
Yes.
IBBI is facing lot of issues where multiplicity of assignment is causing adverse impact on CIRP.
Yes. Yes, sir.
I
Yes, sir.
want to share my personal experience that if you handle one corporate debtor, which is as a going concern, if it is a manufacturing company, 30 days are also low on lower
Yes, sir.
side
Yes,
to
sir.
devote
Yes,
in
sir.
one side. So I
Yes,
think
sir.
10 is also enough, and I think let's
Yes.
move forward
Yes.
and
Yes.
let's accept this for the
Yes,
time
ma'am.
being.
ma'am, in the
Sir,
definition,
yes, ma'am.
will the
Yes,
insolvency
ma'am.
professional,
Sir, one
will
by
the
one.
IP also include IPE according to this definition
Yes,
for
I
disclosure?
already give this proposal earlier to the IBBI. I have submit the letter to them also. The IPE should also be covered. Ki how many proposals should they, how many assignment they can handle.
But they have left the IPE out.
But
They have
they,
left
yeah.
IPE as IP allowed.
So
Ma'am.
no, sir. Later on, they will allow this also, sir. I think now they are only discussing about the IP. After that, they will.
Ma'am,
they
your
will
voice is
take this.
echoing probably because you've got two instruments working side by side.
No. I'm having only one instrument.
My proposal
So
is that
yes, sir.
my proposal is that post 30 days for CIRP and post 1 year from liquidation period, those cases should be excluded from the ambit of IP because you have certain time limit to complete it. And due to judiciary delay, it is linger on for many years. So those should be excluded.
Ma'am, this is
Okay,
Prashant.
got it. Now
Ma'am, this is
we'll
Prashant. Just one more
conclude
thing,
this and yes, sir.
Ma'am, I just want to submit two things. Just for suggestions in this, you can include in your
Bus, please, sir.
Ma'am, with regard to resolution also, when you submit it, that also should not be counted in the case, because once you submit the resolution plan, that should be excluded from the CIRP part. And in liquidation also,
Sir,
once you
I don't think the resolution plan when they have submitted the
Ma'am, you need to
resolution
understand that the IP also have a lot of team. How if you say that a lot of people are saying 5 cases are enough, 10 cases. Do you think that IP will work for everything, each and everything? You need to have a team. The other my colleagues, so those of brothers and sisters are speaking. They should.
So you are
understand the team has to
saying
be.
so final your suggestion is that you want to exclude the RP if there is a resolution plan is pending.
Yes, ma'am. That is same in the liquidation. Substantial assets has been sold. Then nothing remains because lot of cases where a 5-year litigation is going on. What we do? There is no
Ma'am,
peace for that.
one more disclosure probably is awaited that the COC members have to pay the RPs on time. There has to be a time limit for it because today they have given loans of 20 crores to 500 crores.
Yes, sir.
But when it comes to giving a
That regulation is never
that
coming.
is essential.
Yeah.
That's a disclosure
So
which is
this
most important. Otherwise,
this is very important.
everybody
this is
keeps
also
on scouting
important.
for
Yeah.
work only for this reason that they're not being paid in the earlier assignment. They have to fulfill other responsibilities.
Yes, ma'am.
Yeah, this
Yes,
is
ma'am.
this is
Got
not
it.
important.
Now we
This is
will
not important there either.
now we will move on the other discussion paper, sir. So now this is the third one, the code of conduct. Basically, 12th August 2025, this was came.
Madam?
So, yes, sir, please, sir, we will discuss this and at the last of this seminar, we will discuss whatever is left, sir. We'll discuss at the end of this webinar, sir.
Hello, madam.
Yes, sir. Sir will discuss
Madam,
after.
make a voting system. Better it will be good for
Ma'am, just one question.
No, yes, sir. Sir, I will say to the IPA, I will communicate to the IPA, they will make the voting system. If they want to take the vote on this,
No.
they will take. Yeah.
For our suggestions also, if somebody is
Yeah.
not willing, so make
Yeah.
a voting system this, so you can
Sir, now I'm having no voting system. So this will only depend on the ICSI IPA. They will arrange any this type of system. So then only can we do this. So we'll start with this
Can we email the
proposal.
suggestion?
It is.
Can we email the suggestion?
Sir, I will email to the ICSI IPA, whatever is noted here. So I will email to them. So they will put to the board, and you are eligible to submit your own proposal to the IBBI. Because in each and every discussion paper, it is written, you can submit your proposal. So it is proposed that to avoid the duplication and for promoting the harmonization within the regulations, clause 6 be deleted from the code of conduct from the insolvency professionals. So this clause was deleted. And what is covered as per this clause is also here mentioned. In case where the insolvency professional is dealing with the assets of the debtor during the liquidation of bankruptcy process, he must ensure that he or his relatives do not knowingly acquire any such assets, whether directly or indirectly, unless it is shown that there was no impairment of objectivity, independence, or impartiality in the liquidation or the bankruptcy process, and the approval of the board has been obtained in the matter. So basically, they want that this should be deleted. And what is the purpose of its deletion? We'll also say here. This is the proposal. So they want to delete this clause 6. And what is the rationale behind this? The primary argument for the removal of the clause from the code of conduct are as follows. Because there is a duplication and redundancy, the core prohibition and the underlying principle of preventing the conflict of interest and ensuring the impartiality are already explicitly covered and more currently detailed in the liquidation process regulation. So repeating same in the code of conduct lead to the duplication. So basically these provision is already given in the liquidation process regulation and some other regulations also. So they have said this is a duplication. So basically they should be deleted from here. Now clarity and simplicity. So removing the redundant clause can simplify the code of conduct, making it more concise and easier for the IPs to navigate and understand their role and responsibilities under the code. So there should be the clarity and harmonization, the maintaining a single source for such a specific prohibition within the regulation. So they want there should be a single source only. So they want to delete from here, promote the harmonization and reduce the risk of different interpretations arising from similar nature of clauses appearing in the different regulations under the code. So basically this is the for this purpose they want to delete from here. So basically this is the proposal, and now they have said that you can also submit your comment by visiting the IBBI website. For all the discussion paper, they have given this link. So all are invited to submit to the IBBI directly also. Now, if any participant have any discussion or any suggestions for this deletion of code of conduct, they can give the suggestion on this.
I think it's fine. I don't think there
Yes,
is any
yes,
problem.
yes, this is fine. Yeah, so if anybody left over the discussion which is related to the assignment, so they can put their views now.
Ma'am, just want to
Yes,
submit
sir.
here.
Yes, sir.
I had, in between, actually, you started a new
Yes,
discussion.
yes, sir. So
I just
I'm
want to say,
inviting. Yeah,
see,
yeah.
we have to, all my other colleagues also should understand that the IP is not a single work. They need to have a team, and team has to be very
Yes.
polished. Each and every document has to be passed through, and all documents are statutory records. Every day, as somebody was saying, ki in a 30 days, 5 days, you have 5 cases you have to put, and then you have to read like this. It does not work like that. Each stake, as you said initially, that stakeholders have decided all their feedback. We don't know who are the stakeholders in this. If you're saying the bankers and the IBBI stakeholders,
Sir, stakeholders cannot decide. So many times they have still not paid a single money to the IB. So so many times they cannot make any decision. They will give the assignment only. So this is a code of conduct, because this type of assignment basis code of conduct is also given in the if we will see in the ICSI code of conduct is there, because we can audit only 15 companies, 10 companies, assignment is limited. So this type of code of conduct is given by each and every act, not only the
that is for the
IBBI.
tax audit purpose. It is for the tax audit.
Not only tax audit purpose, the secretarial audit is also limited. How many assignment you can do as a secretarial auditor, how many assignment you can do as a statutory auditor. So everything is
So, ma'am, I just
in
give you the
each-
example.
yeah,
Somebody was
we
saying PG.
totally agree
Now,
that
PG, you
you may be
understand
having
that it is on the update on 95. Now, by 95, you admit, and then you give a report on 99. 99 to 100, it may take 1 year to get admit. So what will happen? These assignments also will be counted, or it will be counted from section 100.
So
These all
there
clarity-
should be, I'm very agree with you. So I will say ki there should be some clarity from the IBBI. If any
Earlier,
assignment
ma'am,
is delayed,
earlier was
if
proper.
any
10 CRP cases were proper. More than 1,000 crore claim was clear, because that was giving a clear idea that this is how we need to deal as a IP. But now, if we are mixing everything, then it will become difficult for anyone to survive, as well as to give a proper service along with the team.
Yes.
Individual IP, if somebody thinks that they can do cases justification for 1 or 2 cases, I agree, they can do, but not more than that, and it will not give a proper what do you call service to the entire stakeholders in case one or two.
But sir, IBBI cannot check ki how many team members you have and what is the knowledge they have. So
No,
IBBI cannot
madam, why I want to,
They are getting
I want to
0.25% on the resolution plan. It cannot be justified.
Yes, yes.
Anyways,
want
even if
to-
you have the best of the guys
Sir-
who are supporting you, end
Sir-
of the day, the person who's signing that report or leading the entire assignment is responsible for it. So even if you have a team of 5 people incapable and 50 people who are capable, it is more important as to how you have, led the whole
Absolutely,
process.
I agree. I agree with Kanak Jani that there is a specific provision in the IBC that if IP wants to delegate, then it has to be with the prior approval of the COC. And the system is designed in a manner where the IP is responsible and he takes care of each and everything.
Yes,
Except
sir.
the clerical
Yes,
work.
sir.
You may
IP
get
cannot
support team for
delegate.
clerical works.
Exactly. IP cannot delegate. Exactly.
Yes.
And
Practically, people are delegating. That is a different issue.
in this case
Practically,
of
what is
5,
happening?
and in this case of 5 or 10 of the assignments, they can add, IBBI can add that, okay, once you have filed your final report with AA, then those cases will not be covered. Even if case going for 2-3 years, that doesn't matter. Then that way IP is safe. They can get the.
That's a fair suggestion. That's a fair suggestion. Because see, let's look at it this way. Anyway, after this amended act comes into play,
yes,
whenever it does, and if it comes the way it is being proposed, much of these problems would be resolved, because even in liquidation, they're saying then 180 days plus maximum 90 days. Now, somehow I feel it's very irrational, because in most of the cases, you are not able to sell anything in that kind of a period, and it is only going to harm the market, because everyone will know कि तुमको 180 दिन या maximum इतने में बेचना ही है, right? It will actually destroy value. Anyway, be it as it may be, you are supposed to now file a dissolution application with the COC. Now they are also saying the assets which are left. They are also saying which are not sold left. Now COC will have to decide what will happen. So अब होगा क्या? If I understand the legislative intent correctly, is that you run a process, you close it in whatever days, whatever are the assets are left, they transfer from the CD to the lenders through some structure. Some structure will evolve and the lenders will then keep on selling it. तो the liquidation में जो आपका ये रहता है ना कि 80 दिन में अगर करना है, हो ही नहीं सकता, हो ही नहीं सकता।
सर दे
I'm
प्रिंसिपल
telling you from the
एक
experience of
प्रिंसिपल हम
8 to
सब
9
लोगों को एक्सेप्ट करना चाहिए आरपीस को कि जब तक असाइनमेंट्स में उनकी पर्सनल इन्वॉल्वमेंट नहीं होगी, लीडरशिप नहीं होगी, तो ये जिंदल जेएसडब्ल्यू जैसे जजमेंट्स आते रहेंगे। हम लोग प्रैक्टिकली असाइनमेंट्स लेते हैं किसी और की हेल्प से, वही आदमी लोग ड्राइव करते हैं, ये ओपन सीक्रेट है मार्केट।
Exactly.
और जिसी वजह से हमारे प्रोफेशन की बदनामी हो रही है।
100%, 100%.
100%, sir, is agree
Hello?
with you. And sir, some of the capable person who are
Hello?
not getting the ball on the pitch, they are not having the chance to
Why is that?
सर बहुत सारे
Why is that?
कॉम्पिटेंट लोग हैं जो मार्केटिंग में एक्चुअली में लैक करते हैं ना। कुछ लोग मार्केटिंग में स्मार्ट हैं, वो लोग लेते जा रहे हैं असाइनमेंट। और देखिए मैं तो आरपी हूँ इसलिए बोल रहा हूँ, हम लोग सब प्रोफेशनल्स हैं कि हम लोग खुद ही अपने पैरों पे कुड़ाली मार रहे हैं, क्योंकि हम लोग ऐसे लोगों को एनकरेज करते हैं कि जो लोग असाइनमेंट लाते हैं फिर उसमें फीस शेयरिंग करके कहते हैं आप सिर्फ साइन करते रहो। हमें खुद इस चीज को आगे बढ़ के ना डिस्करेज करना चाहिए।
जब तक इन्वॉल्व होके नहीं काम करेंगे और लॉस को बहुत ज्यादा हम लोग खुद नहीं जानेंगे, तब तक हम कोई भी असाइनमेंट अच्छे से नहीं हैंडल कर सकते सर।
मैडम
जी सर।
पर आपको ऐसा क्यों लगता है कि जो एग्जिस्टिंग सीनियर आईपीज हैं वो ऐसा कर रहे हैं? फॉर एग्जाम्पल
सर
सुनिए मेरी बात, मैं अपनी बात तो कह सकता हूँ। इन माई केस आई ड्राइव द किसी की मैं सुनता नहीं हूँ, ठीक है? और सीओसी भी फ्रैंकली मेरी सुनते हैं। एंड दूसरी बात, आज आपके ऊपर सबसे बड़ा रिस्क क्या है मालूम है? एज ए आईपी मैं अभी नया असाइनमेंट लेता नहीं। क्यों नहीं लेता? क्योंकि आई नो माई बैंडविड्थ इज फुल एंड आई एम लायबल। सो ये आप उतना ही लोगे। फॉर एग्जाम्पल, इफ आई हैड ए रनिंग कंपनी, there was a time when I had a running
sir,
company.
I have
उस
already
समय मेरे
shown
पास
you
और assignments थी
the
नहीं।
sir आप आईपीसी की IBBI की लिस्ट देखिए यहाँ पर, कि ये देखिए 27 is already ongoing assignment है ना, and completed only 3. So
मैडम
sir,
वो ना डबल
at
काउंटिंग
least
है।
sir,
मैडम स्टेटस चेक करिए
हाँ,
केसेस
sir,
के, अगर वो आईआरपी आरपी वाला
हाँ,
स्टेटस है, फाइल हुआ है, लिटिगेशन में है, कहाँ अटका है, लॉट ऑफ थिंग्स, कॉम्बिनेशन प्रमोशन परमुटेशंस आर देयर।
And with due respect to everything, you have only 24 hours and you have only 30 days in a month.
Yes, sir.
So how will you justify that time? Where will you get
But
that
does
time?
it apply to the prime minister and everyone also, because the time is limited? So everyone has to wait for work limited.
Exactly.
Does it apply that also?
That is applied to everyone.
The RP has done, and how many assignments?
So will I think the conclusion will not be came
in how
on
many
this
assignments
point.
RP got fees?
Sir, because the time is already going on, so I think we should conclude now. And if any suggestions you have as a
No, we have
participant-
given the
Yeah.
suggestion. Madam Anjali should know
Sir,
this.
sir, yes, sir.
There were some of the suggestions were very practical.
Yes,
that
sir.
the assignments which
So-
are already
so-
over, dissolution applications have been filed, or
I have
resolution
already written
applications,
here.
this thing.
Yes, sir.
These
I
things should be excluded from this 10.
Yes.
Okay.
Yeah,
Now
yeah.
coming to people talking about, आपके पास इतना टाइम कैसे मिलेगा 24 ये much of the IBC cases which are there today, the companies are not functional. The moment you start handling one case where the company is functional, I can assure you as a RP, as a IP, you yourself will not be dare to take another case because you will be so stretched. In one running company, I have done that. उस समय मैंने कोई assignment नहीं की. I just ran that company.
Yes,
And
sir.
thankfully, since I ran that company, I could generate the revenue and get my fees also. Otherwise, the COC was not paying. But liquidation में क्या होता है? या companies जहां पे आप IBC लगा देते हो, but dead asset है, in a way. Actually, as Dr. Sahu used to say, sometimes it is beneficial to directly liquidate also. अगर कंपनी में कुछ है ही नहीं, आप सिर्फ भी CIRP लगा रहे हो. CIRP के जगह में सीधा सीधा आप लिक्विडेशन क्यों नहीं लगा सकते? ये सब कोड में आना चाहिए.
ठीक है सर.
बिकॉज आप CIRP करोगे, आपको
सर
फलाना ये करना पड़ेगा. एक रुपया नहीं आता यार.
अर्ली डिसोल्यूशन 2020 से चल रही है. आज 2025 तक उसका कोई निकाल नहीं. अर्ली डिसोल्यूशन.
और आपको पैसे भी नहीं मिले होंगे.
बिल्कुल.
So
मेरे को भी
I
पैसे नहीं मिले. मेरे एक केस में तो 3 साल से पैसे नहीं मिले. अब रेजोल्यूशन प्लान आया, सुप्रीम कोर्ट में जीत गए.
5 साल से नहीं मिले.
सर तो कुछ ऐसा भी आना चाहिए which is on the fee of the IP also कि how many days should be permitted to
वो तो
release the- yeah.
IBBI लाने से रहा.
नहीं
आपने
सर,
भी
if
बताया
we
होगा.
will say
this is
regularly,
much awaited.
if we will
बैंक को
say
नाराज नहीं कर
regularly,
सकते है ना.
सर बैंक को तो सर आरपी भी नहीं नाराज करते हैं ना. बहुत से आरपी भी नहीं नाराज करते
तो
हैं.
फिर इम्पैनलमेंट के अगेंस्ट कौन बोले? Who's going to bail the cat?
I have said so many times to the IBBI, not made the
Another thing,
empanelment,
nobody-
not permitted the empanelment from the bank
Nobody
separately.
charged below the minimum fees.
आपको मालूम है ये
we
जो मिनिमम फी जो हो गया, मिनिमम फी
Yes.
प्रेस्क्राइब कर दिया,
Yes,
वही अभी लगभग मैक्सिमम फी हो गया.
yes, sir.
राइट.
Yes,
The
very
idea
yes.
was कि IP मिनिमम इतना कमाना चाहिए, एंड IP को अगर लेना है तो अलग से ले लो. ठीक है.
Yes.
नाउ
Yes.
IP छोड़िए. सपोजिंग यू आर ए IP, यू आर ए कंपनी सेक्रेटरी, लॉयर, व्हाटएवर. आप अकेला तो एक पूरा असाइनमेंट हैंडल नहीं कर सकते हो. Sitting alone.
Yes, sir.
You will
Yes,
keep
sir.
some staff.
Claim verification is very tough.
You will keep some staff.
Yeah.
Madam, there
Yes.
is
You will
one
keep
Madam,
some
you
staff.
know
You have a-
that
only
what
Yes,
you are
banker
allowing
says.
on 2-3
Yes,
participants.
Madam,
sir.
what
Please,
banker says with regard
sir.
to fees, what
Sir,
they say
please
कि in
allow.
the code it is mentioned
Hello?
shall for the IBBI fees,
Taking
may
less
for
than
the
minimum
IP
fees
fees.
should be banned.
That's the reason we have
Madam,
kept
there
it
is-
as a minimum as a maximum.
Yes, sir. Sir,
Madam,
say
there is one
something.
40
Yes,
participant.
sir.
Only the 3 participant is giving views of 1 hours.
Sir, please, you say something, sir.
If you
My-
want to give your view, nobody is
You
preventing you.
say, sir. Say, sir. Whatever you want to say,
नहीं,
please
I
say.
am saying कि David, I see the क्या नाम है going concern. I was a consultant on there. I
Yes.
see how the work going concern is going. There is one plant is not able to give the whole times. There is lot of problem in there. And if you say one, because if you are the IP, you are a very kind of good repo. You choose according to your why you are take 10, 20. Okay,
Yes.
because you have
Yes.
the choice. Don't go for the liquidation. You go to CIRP. Who is stopping you?
So I noted the suggestion, whatever is said here, and I think ICSI IPA is already noted, and you have also the right to submit your suggestion to the IBBI directly. So now I will conclude this webinar here. So we'll discuss further if any other changes will come. So thank you to the ICSI
Thank you,
IPA
ma'am.
and
Thank you
all
very
the
much.
participants. They have
Thank you,
taken the
thank you.
initiative. Thank you so
Thank you
much.
very much.
you.
Madam.
So, we'll
Thank you,
stop.
thank you everyone.
Thank you, everyone.
Good to learn now.
Thank you, sir.
ऐ वतन तेरे लिए दिल दीवाने जान दे